Right, good morning everybody, and welcome to a short video clip on an introduction to law. Massive welcome to all my new law students for year one, purple and red. If you remember, last week we went through an introduction to law, and our first question was, what is law? If you remember, I clearly stated law is simply a set of rules normally imposed by the state. So typical examples of laws we're all familiar with, even if we didn't study law, would be you are not allowed to kill or steal or hit another person without their consent. So what is law is simply a set of rules that we must follow. We also had a quick chat about why we have to have laws, and we clearly agreed that without laws or measures or instructions, then we would have chaos and everybody would be able to do whatever they liked and society would hardly function effectively. So we know what law is, a set of rules imposed by the state. We know why we have laws, and that's because it's to prevent anarchy or disorder. Now, the next thing we asked ourselves were there were two main types of laws. There's criminal law and civil law. If we start with civil law normally relates to two or more individuals who have a disagreement. So the typical example I gave was if I went into a supermarket, any supermarket, and slipped on a wet patch and hurt myself, then I'll be arguing with the supermarket, just in case I'm not willing to solve the problem straight away, that they owe me compensation for my injuries. Now, we went on to identify that if that case went to court, then I would be the claimant because I've injured myself. We also identified that the old word for claimant was plaintiff. So most of the cases that we read in civil law or in tort and under the English legal system would be old cases. And a typical example of a case I asked you to read and have a look at was the case of Donoghue and Stevenson, and that was in 1932. So it's a long time ago. So Donoghue, Mrs. Donoghue, who suffered an injury by drinking ginger beer contaminated by a decomposed snail, was the claimant who was able, or was the plaintiff at the time, who was able to claim compensation. So civil law is a disagreement between two or more individuals. We have also identified that the lowest court that you would make a civil claim is the county court, even though I also mentioned that the magistrates court has some civil jurisdiction. So for example, they may issue licenses to public houses who might want to trade and so on and so forth. Right, we also looked at criminal law. Now, criminal law is simply to do with where an individual, the defendant or the prisoner or the accused, does something wrong against another person. Technically speaking, the defendant does something wrong against the state rather than an individual. So in criminal law, anything we do that's against the law is usually considered to be done against the state. So a typical example of a criminal law case is cited as the Crown and, for example, Stephen, if Stephen is the defendant who's done something wrong. The Crown is usually represented by a government agency called the Crown Prosecution Service, the CPS. There's one based in Nottingham, and they're scattered across the country. But they have the responsibility of prosecuting offenders if they commit any offences. Excuse me. Right, so we've had a quick look at criminal law and civil law. I gave you cases such as Donoghue and Stevenson, Donoghue and Stevenson, also Borehill and Young. We also had a look at the case of Carlin and the Carbolic Smoke Ball, and also criminal cases, the Crown and Brown, and the Crown and Woolen. These were all cases that depicted what happens in the civil law, to say there's a dispute between two individuals, and also what happens under criminal law to suggest that a defendant has done something wrong against another person. Now, the other thing we spoke about was the standard of proof in civil cases. So if I was claiming compensation from the supermarket that I slipped in, then I have to prove my case on a balance of probabilities. If you remember, that simply means that it's more likely that my story is true and correct, and therefore I'm due compensation. The figure I suggested out of 10 would be I have to have maybe 6 out of 10% worth, 6 out of 10 amount of evidence. because the standard is not too high. Now, in criminal cases, we all agreed that the defendant's liberty is at risk, and therefore all the evidence has to be watertight. So in criminal cases, the prosecution on behalf of the state, we spoke about the words such as Regina for the Queen and Rex eventually for a king. But the Crown Prosecution Service, in order to win their case or to secure a conviction, would have to bring proof beyond all reasonable doubt. And that's because, as I said before, the liberty of the defendant is at risk. And therefore, before we put anybody away in prison or before we take away anybody's liberty from them, we have to be 100% certain that we've got the right person who committed the offence. Right, now we also had a quick look at different sources of law, and we agree that a source is where you get something from, and we started by identifying that the most important source of law was an Act of Parliament. An Act of Parliament is referred to as legislation. Another word for an Act of Parliament is also statute or statute law. So in England, Wales and Northern Ireland, the most important source of law that we have are Acts of Parliament. Typical examples of Acts of Parliament that we will be dealing with on the A-level law course would be the Offences Against the Person Act 1861. In addition to that, we'll also be dealing with the Theft Act 1968 and also the Occupiers Liability Act 1957 and 1984. Other Acts of Parliament we deal with include the Homicide Act 1957, in particular Section 2 as amended, and also the Coroners and Justice Act 2009. So these are all typical examples of Acts of Parliament, and these are sources of law. The second one we looked at was common law, judge-made law, judicial precedents, stare decisis. All these are typical examples of laws created in the courts. We also spoke about EU law, which we watch this space at the moment and see how that develops. And the other example of a source of law was custom, something that happens over and over again. The example I gave was the right for the fair to be held in Nottingham, the Goose Fair to be held in Nottingham, because it'd been held in Nottingham on a particular site, the forest site in Nottingham, over many, many years, over 700 years. So it's customary that they have the right to hold that fair and nobody can challenge them as trespassing. Right, in addition to that, the last thing we had to look at was to do with the court structure. The civil court structure normally starts with the county court, even though we have the magistrates court, which has some civil jurisdiction such as licensing. But the county court is the court of first instance for civil cases. So in my instance, or in the example I gave about me slipping in a supermarket, I would start my claim in the county court, and depending on how much I'm claiming for, there's a form to fill in called the form N1, which I would need to fill in and put my side of the story across to the court. The next one above the county court would be the High Court. There are 3 divisions in the High Court. We'll look at that later, but there's the Queen's Bench Division, there's the Family Division, and there's the Chancery Division, and all these different divisions deal with different things. So the Chancery Division deals with wills and probate and bankruptcy. Family Division, as its name suggests, deals with family issues such as divorce, separation, custody issues, and the Queen's Bench Division deals with contract law cases, tort cases, and so on. Now, after the High Court, we then move on to the Court of Appeal Civil Division. That's an appellate court, so they deal with appeals, and the highest court in the United Kingdom, in England, Wales, Northern Ireland, is the Supreme Court. The Supreme Court used to be called the House of Lords. In the criminal courts, the court structure from the bottom starts with the Magistrates Court. The Magistrates Court is such an important court because it deals with nearly 95% of all cases. In addition to that, from the Magistrates Court, we have the Crown Court, and then after the Crown Court, we have the Queen's Bench Divisional Court of the High Court. So the High Court, generally speaking, has civil jurisdiction, but it also has criminal jurisdiction in the form of the Queen's Bench Divisional Court. From the Queen's Bench Divisional Court, we then have the Court of Appeal Criminal Division, and then above that we have the Supreme Court. So that's a clear example of the court structure for criminal law and civil law. And that is a quick introduction to law and all the issues that we dealt with last week. Please make sure you view this video and make sure you do read read the PowerPoint slides that we discussed last week. Thank you for watching.